All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Cardavia Scott, CR 25-214. Mr. Scott was set for arraignment. He's been in Washita Parish. We had an indication or notes from Washita that he bonded out on February 13th of 26. And it appears that there should be a magistrate's warrant for surrender of principal. So we're going to double check on that and then we'll recall it. Shiloh Scott. Morning, Mr. Harrison. James Grossell. Is it Grossell or Grossell? Grossell. All right, and Gina Prox, Ms. Prox is appearing via Zoom with court permission. She is logged in. We can call that case when ready. Junior Spence. John Tadlock. And Misty Tadlock is here. Andrea Young.
She is walking up the stairs.
Thank you, Mr. Thorson. I'll take you at your word. James Burleson. Brett Goollet. And Dil Shapati. All right, do we have any counsel that's ready? Not everybody at once. No counsel that's ready?
I think our case requires announcement, but perhaps
Okay.
Scott.
Okay. Y'all want to make an announcement now, or I think we have it set today on the state's motion for continuance, I think. Do y'all, so I understand y'all wanted to meet about that? Do y'all want to meet about that, or you want to make an announcement?
Yes, Your Honor, we think it's probably most appropriate.
Okay. All right, we'll recall that case then. Mr. White, are you ready by chance?
I'm ready to, Your Honor. Thought with Mr. Burleson, the papers came through, but I'm ready on Mr. Spotty, Mr. Bill.
Mr. Spotty, come on up. This is cause number CR 25-136. State versus DL Shapati. Leave her set for docket call, Mr. White.
Defer to Mr. Hernandez on this one.
Morning, Your Honor. At this time, the state would tender a motion to dismiss the approach.
You may. Sir. All right, Mr. Shapati, the state has tendered a motion to dismiss, indicating that the complainant in the case has requested dismissal. Court hereby grants the state's motion. Mr. Shapati, you're free to go.
Thank you very much.
All right, for the record, the court has signed the motion to dismiss. Or signed the order to dismiss. Who else did you say you were ready on?
Mr. Goolett.
Brett J. Goolett, CR 25-234. And Mr. Goolett is also set for docket call.
Yes, sir. Mr. Hernandez and I were discussing this case yesterday, and Mr. Hernandez was ensuring that I had everything, and he was asking me about some medical records, and I had seen, and for whatever reason, they were showing on the LGS side on theirs that they were uploaded, but in my portal, I had never seen them, and they weren't in there. Mr. Hernandez got them put in there immediately. I've got a few of these. It looks to me that there's about probably 260 something pages or so, and I haven't had a chance to look at them. So if we could have one more docket call.
Any objection from the state?
No, Your Honor. Thank you.
All right, court's going to set Mr. Goolett for final docket call. Mr. White, I've got April 2nd.
I bet that's going to be okay, Judge, but let me make sure I don't have anything else. Which I think that'll be okay.
All right, court sets Mr. Goollet for final docket call, April 2nd at 9 a.m. Ready to go. Okay, yeah, just a second. Mr. Thorson, you, Miss Young, ready? Miss Young, come on up. All right, this is cause number CR 22-121, state versus Andrea Nicole Young on the state's motion to adjudicate. Mr. Thorson's court's understanding, you were just recently retained.
That's correct.
And the court had granted your motion for continuance. I just wanted this as an initial appearance from Ms. Young on the state's motion. Court will reset this to the contested docket on April 30th at 9 a.m. And just make sure that you get your discovery set up with the state.
I will, Judge. Thank you very
Alright.
much.
If there's nothing else, Ms. Young, just reminder, you're still on probation, you're still on community supervision. So you need to be complying with all of the orders that the courts previously placed you under. Just because they filed a motion doesn't mean you should stop. And I'm sure that Mr. Thorson's already counseled you on that, but I want to remind you again, okay? All right, ready to go.
Does she need a reset form, Judge?
Yes, yeah, did you fill one out, Mr. Thorson?
Not yet. I will.
Second. Chris. All right, court's going to stand in recess and give Mr. Maney and Mr. White time to work with their clients. It's about 9:15. Court will probably be in recess till about 9:45. All right, good morning, Ms. Prox. Can you see and hear me okay?
Yes, sir.
All right, I'm going to call your case. Your attorney, Mr. Manning, is in the courtroom. If you can't see him, if you're on a phone, you may have to swipe left or right, but he's present today also. This is cause number CR 24-220 and 221, State of Texas versus Gina Lynn Prox. We're set for docket call. For the record, Ms. Prox is appearing via Zoom. Court understands that she is ill and the state had no opposition, and that she is in substantial compliance with the pretrial release conditions. Mr. Manning, any announcements from Ms. Prox on docket call?
Judge, no announcement to request to remain on status pending the resolution of the co-defendant's case. Additionally, Judge, I did speak to Ms. Prox about her $35 balance, and she said she will get that paid. She has money set aside for that. Normally pays it when she's here, but because she did make the trip, she will get it paid online.
All right, Ms. Prox, the court is going to reset you. I'm going to set you out a little bit further. I'm going to set you out April 23rd. April 23rd. And that'll be at 9 a.m., okay?
Okay.
Need to report to your pretrial release officer at his office and get that delinquency paid. You understand?
Yes, sir.
All right. All right, you're free to go. We'll see you back on April 23rd.
All right. See you then.
Judge, next ready, Mr. Gristle.
All right, Mr. Gristle, come on up. CR 25-202, State versus James Chandler Gristle, I believe. Mr. Gristle set for docket call.
Judge, previously there was a no offer by the state. The state has made an offer, and because of my client's being in medical facilities, I was unable to have a conversation about that along with going over the discovery. We'd request one additional docket call for him to weigh the offer along with the discovery and evidence in this case.
Any objections from the state?
No objection, thank you.
All right, court will grant Mr. Gristle's request and sets docket call April 2nd at 9 a.m.
Thank you, Judge.
Once he signs his notice, it's free to go. You're free to go.
Next, Mr. Junior Spence.
Junior Lee Spence. This is cause number CR 25-103. Mr. Spence is set for docket call.
Yes, Judge. At this time, we were announced ready. Judge, we do request that if the state, in speaking to their complaining witness and reviewing in preparation for trial, if they do come up with a different resolution, would ask the court to entertain the potentiality of a plea in the future if that so results from the conversations with the complaining witness.
Understood. And what offer has the state made that the defendant is rejecting today?
Judge, I believe that our last offer was 6 TDC.
And the court will grant the request for the court to consider. That does not commit the court to allowing the defendant to plea in the future, regardless of what the state's offer is, if your client understands that.
Yes, Judge.
But the court will entertain, if there's a disposition, the court will entertain the suggestion. All right, the court will set Mr. Spence then on the trial docket. I will begin on April 6th. So, Mr. Spence, on April 6th, your case will not be set for trial, but you'll need to appear on that day downstairs. Don't come in here. There will be a jury selection going on. You'll meet downstairs. My staff will be down there. They'll get you signed up. Pretrial release officer will be there. And so you'll do that until your case is set. You're charged with aggravated sexual assault. So it's very likely that the court may give you a special setting here in a few months. But for now, I just want you to report on April 6th. All right. Who's next?
Judge, already on the Tadlocks?
All right, Mr. and Ms. Tadlock, y'all come up together. Court calls cause numbers CR 25-105, 106, 107, 108, 109, 110, 111, 112, 113, 114, State of Texas versus John Michael Tadlock and also Misty Amber Tadlock. Court finds that Mr. Manning has been appointed to represent both. And I believe that we are set for final docket call in each of the cases. Go ahead, Mr. Manning.
Yes, Judge. After speaking to the state, just a while ago, we would request one additional, docket call for us to negotiate a settlement conference and see if we can't, come up with a resolution before we set on the trial docket. My clients expressed openness to that, and so that will give us some time to come together with some solid opportunities to get them to sit down with the state and reach a resolution.
States agreed. All right, then court will grant their request. Court will set the Tadlocks for final docket call. I'll move them out to accommodate y'all schedules for the settlement conference
Thank you, Judge.
to April 23rd. Each case.
And Judge, may they be excused.
Yes. I do show that they are delinquent on their financials, so we make a payment today.
Judge, they made a payment on today at 9:26 on both cases. It's zero balance.
Zero balance. Okay, thank you very much. Thank you.
Literally, that's good on business this morning, maybe.
Yes, thank you, Mr. Manning. All right, counsel, can you approach? On the. Scott, if you'll come up, this is cause number CR 24-225, State versus Shiloh, Darnell Scott. We're set today on the state's motion for continuance. Mr. Hall, I believe that you filed that. Would you like to proceed?
Yes, Your Honor. Court is well aware this alleged offense occurred on or about July 4th, 2024. Shortly thereafter, tissue swabs were taken from the vehicle driven by the defendant. Those swabs, along with buccal swabs taken from the mother of the victim, were submitted by the DPS trooper to the University of North Texas Center for Human Identification on July 16th, 2024. The request was made that the lab analyze the swabs for mitochondrial DNA. Comparison of those swabs to determine if the tissue could be identified as coming from a daughter of the known buccal swab submitter, the mother of the victim. This case was originally indicted September 27th, 2024. And in July of 2025, it was moved to jury selection docket and set for March 16th. In January of 2026, counsel for the state began reviewing the evidence to prepare for trial. We contacted the University of North Texas lab and learned that the DNA analysis was not yet complete. After conversations with them, they represented to us that the analysis could be completed in time to allow for timely filing of the expert designation and report before trial. However, when that date arrived, counsel again contacted the lab and could not reach the person who was responsible for this case. Eventually, the individual responsible was contacted, and it was learned that she had been out on sick leave for the previous week, so the testing was not completed. The DA's office received the DNA report from the lab February 18th, 2026, which was less than 30 days prior to the March 16th, 2026 trial setting. We immediately forwarded that report to defense counsel, and the report was delayed through no fault of the state. It's just simply an operation of how many cases the UNT lab has, all of them being serious cases, most of them involving a death, as this case involves. We have met with or consulted with defense counsel Brett Harrison, and have been informed by him that he does not object to this motion for continuance. We're trying to get everything ready to try the case so that justice may be done, the full evidence may be complete and available for submission before the court to the jury. And due to the late receiving of that, we believe that in the interest of justice, it would be fair to reset this to August of this year. We have met with the victim's family. They're not opposed to that being reset, and we would ask the court to grant the continuance.
Thank you, Mr. Hall. Any response? It's not necessary, but response if you want to.
Well, I would like to comment, Judge, it may please court. Judge, let me back up a little bit further, maybe even. So this case is currently specially set for trial, jury trial, March 16th, 2026, this year, next month, or later this month. Originally, this case was indicted on September 27th, 2024. This was an accident leaving the scene that resulted in a death allegation. And that's what the indictments pled. So since September 27th, 2024, we have been dealing with the case. On July 1st, 2025, after extensive negotiations with the state, both we and the state recognized we were not going to come to an agreement on this case. And we asked for this case to be moved to March 16th, 2026 for jury selection on a plea of not guilty. Between July 1st, 2025 and the week of February 16th, 2026, essentially nothing of substance occurred as far as the posture of the case. On February 11th of this year, Ms. Curry called me and indicated to me that there was not DNA that the state had in its possession. They had not had testing that had been completed and certainly did not have any results of DNA that they had received. But she indicated that they were going to try to rush that process. So she made that call to me on February 11th of this year. She called me again the next day on February 12th, saying that she believed that their indictments that they currently had that had been pending since 2024 was not appropriate, and that she would seek to take the case back for a superseding indictment the next grand jury meeting, which would have been about 10 days or so from that point. She did not tell me precisely what the new allegation would be, what the new wording would be, but did indicate generally that it would make for an easier time of proof by alleging an alternative method of proof. So that phone call came to me on February 12th of this year. We did not receive the new indictment until February 23rd of this year. And in fact, the new indictment that we have had now for less than 2 weeks has expanded the state's ability to seek and receive a conviction from a jury. It has, in fact, lessened their burden of proof substantially. And it certainly has impacted my trial strategy. And we've had that indictment and been able to look at that indictment for less than 2 weeks at this point. We received DNA on February 19th. We received the DNA, and 2 days later, I believe we received the litigation packet, which contained the underlying data. That consisted of what I believe to be about 117 pages. Going back, prior to the phone call I received on February 11th, which was my first indication that there would be DNA in this case. Because although in the offense reports and in the state's discovery, there was a reference to swabs being taken at or near the time, there was no indication that anything had been done with them. Certainly there was no indication that DNA results were imminent. There was no autopsy. There were no medical records. There were no EMS records. There was nothing of a medical or scientific type other than swabs being taken at the scene. So my first indication that DNA would be brought up and used as evidence by the state was that phone call on February 11th, and then receiving the actual DNA results in the litigation packet on February 19th, about, again, less than 30 days from trial. So from July 1st, 2025 until February 11th, and the dates, the July 1st, 2025 is the date that we set this case for trial. I believe that we would not come to a resolution. So from that date, July 1st, 2025 until February 11th, 2026, we believed we were going to trial on the original indictment that had been pending for 2 years without DNA, which we had never received or never had any indication that was forthcoming. And all of that changed the month of February. Prior to that, on February 2nd through February 6th, I was in a week-long jury trial in Tyler, the 114th, on an engaging case with an aggravated robbery underlying, which was a 15 to life. And I say that just to let the court know we have not been sitting on our hands. We have a full law practice. So once we finished with that trial, that took about a week after having changed our entire calendar to make ourselves available for other settings and resettings and things of that nature, I get the call from Ms. Curry, and everything kind of explodes in this case. So I filed a motion for continuance on February 17th, referencing the fact that Ms. Curry was going to take this case back to grand jury the week of February 16th, and indicating that she had told me that that would be involving an alternative method of proof for this offense. And again, in my experience, that would be expanding the ability to get a conviction, and after having seen the indictment, it certainly does so, as well as lessens the burden on the state. My concern, Your Honor, is that this case had been pending since 2024 on an indictment. The indictment gets changed, which the state certainly has the authority and the ability to do, within 30 days of trial, of a special setting of trial. And it's not simply an indictment that changes a few things or cleans something up or takes out surplusage. It, in fact, changes the entire aspect of the case, in that it changes the state's ability to get a conviction, it lessens their burden, and it changes my trial strategy. And all of that is within 1 week of our special setting. Throw onto that the fact that we now have DNA, which, again, for the last 2 years, yes, swabs had been taken at the scene, but as the court knows from practice, and as the counsel for the state knows, and as I certainly know, the fact that swabs are taken at the scene never means that there's going to be DNA presented at trial, nor does it mean that there's actually ever going to even be testing of the DNA. And so for 2 years, nothing happens. And then 30 days before trial, all of a sudden we get DNA that we've got to deal with. So I filed the continuance on February 17th based on the new indictments. The court denied that motion because it was not right at the time, because we had not actually seen the new indictment at the time. My hope was that the court would reconsider the motion once it became right, which it has, but I think the court, again, has denied that motion. The state filed their motion on the 26th, February 26th, talking about the DNA aspect of it. And I certainly agree with them and join in their motion. The state in their motion has indicated that there is a trial that they will be ready for if the court were to grant our motion. The state has indicated that the family of the deceased has no objection. We certainly want the case continued for the reasons I've stated. And so we would ask the court to reconsider the court's ruling on the denial of the state's motion of continuance. My concern is that if we are forced to go to trial on a new indictment that happened 1 month or less prior to our trial setting, and with DNA, newly given results for DNA, less than 1 month before trial, that puts the defense and the defendants prejudiced under the 6th and 14th Amendments of the United States Constitution, Article 1, Section 10, Texas Constitution. It is violative of her due process rights. It does not allow me to fully and effectively represent her under the 6th Amendment. It curtails my ability to present a defense. I've only dealt with this indictment since laying eyes on it on February 23rd. That is the first time I've seen this new indictment. And so I believe that she would be absolutely prejudiced if we're forced to go. So I would ask the court to reconsider. For what it's worth, I object to the court's ruling on the denial of the continuances.
Well, I haven't said I've denied it yet, but
If the court were to deny it.
and so I just want to correct some phraseology that you've used, just so it's clear on the record. You said that this new indictment lessens the burden of proof,
Yes,
less than beyond a reasonable doubt.
it lessens the burden in that it establishes a new mental state that is a lesser burden for the state to prove.
But the burden of proof is still the same.
Burden of proof is always beyond a reasonable doubt. It is easier for the state to obtain that on a lesser mental state that they've alleged.
Thank you. State, do you want to respond at all to Mr. Harrison's comments on the timeliness of the representation of the case to the grand jury?
Your Honor, as to the timeliness of the representation of the case, I believe that the cases would say that the defendant has to have 10 days notice to prepare for trial, just on that aspect of it. Now, obviously, this is not a routine run-of-the-mill case, as Mr. Harrison has outlined for the court. There's a lot of scientific stuff, to use a technical term, scientific stuff that he would want to be able to analyze and prepare for. But the fact is, it's timely for the reindictment. If he didn't get it until February 23rd, that's 10 days today. And today is 11 days before the trial setting. So that aspect of it, I don't quite get. But I do believe that in the interest of justice, in the interest of fairness, that we should be able to present this case in its entirety as it has been indicted, as it's currently indicted, and that a reset is not going to hurt anyone. We have contacted the victim's family. They understand the situation that we're in, and they have agreed that they would not object to that. So,
Thank you, Mr. Hall. All right, then the court, having considered the state's motion for continuance, for the record, the state indicated that it believed that it was untimely on the disclosure of DNA evidence to the defense by being less than 30 days prior to trial. Court finds that there is no such 30-day standard, that in fact the court standing order, which is derived from the Texas Code of Criminal Procedure, Article 3914, says that all expert witnesses and reports on their expert testimony must be disclosed no later than 20 days prior to trial. Court finds that any provision of DNA evidence prior to 20 days is timely under the court standing order and under Texas law. Court finds that the representation of the case to the grand jury, the amendment or the reduction of a superseding indictment is not untimely under the law, and that there's no motion by the defendant to quash such indictment. Court finds no legal reason that this case should be continued. Court has concerns that if it does reset the case at the request of the parties, that doesn't prevent some factual issue occurring between now and the reset that could cause the case to be further delayed. The fact that this case has been set, specially set at the party's request since July 1st of 2025 and has been pending since July of 2024. The court hereby finds that it is in the interest of justice that this case proceed as scheduled. And the court hereby denies the state's motion for continuance, denies the defendant's motion for continuance, oral motion, or the joining of the motion with the state. So I understand, Mr. Harrison, I would like to make a record ex parte. I believe that there's no objection from the state. Is that correct?
no objection, Your Honor.
All right, so the court will make accommodations for Mr. Harrison to make some further objections and statements on an ex parte basis. All right, then if there's nothing further, then we are adjourned in this hearing on the record. Mr. Harrison will make some accommodations for you in the court's chambers.
Yes, sir. When would that, is that now?
We'll do that now.
Yes, sir.
Mr. White, are you ready on your plea? I do. So, Mr. Harrison, it'll be just a moment. I'm going to do a plea for Mr. White. So, go ahead. All right, court calls, cause number. It's Mr. Burleson, correct?
Yes, sir.
Clause number CR 25-92, State of Texas versus James Darrell Burleson. Mr. Burleson, if you will raise your right hand, place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, Glory. All right, your name is James Darrell Burleson, is that correct?
The second, yes. The second, yes.
The second? Okay, I'm sorry, I don't have that on here. And Mr. Burleson, are you a United States citizen reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes, sir.
Do you have any questions for him about anything that you have read and signed today that you may not understand?
No, sir.
Mr. Burleson, you were indicted with a second-degree felony offense of aggravated assault causes serious bodily injury. And I see that today there's a plea agreement for that charge. The range of punishment for a second-degree felony in Texas, if you were to be convicted and sentenced, is confinement in prison for not less than 2 years or more than 10 years. I'm sorry, more than 20 years, not less than 2 years, not more than 20 years, and a possible fine not to exceed $10,000. I see that the plea agreement in your case is you intend to plead guilty to that crime. In exchange, the state's recommending that the court accept your plea, sentence you to 8 years confinement in prison. They're also recommending that the court suspend that sentence today and place you on 6 years of community supervision, along with a $2,000 fine, and that you must complete a VIP program, which is a batterers intervention program. As a condition of your community supervision, you would also be responsible and assessed court cost of $290 and reimbursement fees of $35.
Yes, sir.
Is that your understanding?
Yes, sir. Oh,
Counsel, can you approach for a second?
Yes.
So, Mr. Ferguson, understanding the range of punishment, understanding the plea agreement, how do you plead to aggravated assault causes serious bodily injury?
guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
No, sir.
You're not guilty of committing that crime.
Well,
I'll take, Your Honor, before we go further, let me, if we can go off the record, let me talk to Mr. Brooks.
Yes, sir. Take a moment. All right, court is back on record, CR 25-92, State versus James. Daryl Burleson, second. Mr. White.
Your Honor, I talked with Mr. Burleson. We talked this through. He just kind of had a misunderstanding. he's ready to answer the court's questions at this point.
Mr. Burleson, I asked you previously if you are pleading guilty because you are in fact guilty of committing the crime of aggravated assault causes serious bodily injury. What is your answer?
Yes.
And you're pleading guilty because you did commit the crime, not because you just want a certain plea agreement. Is that right?
Yes.
And Mr. Burleson, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. White, any objection to the evidence being admitted?
No, sir.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, Your Honor, state is in compliance.
And victims compliance?
State is in compliance.
All right, anything further from defense?
No, sir.
All right, court's going to review the evidence. So, Mr. Hernandez, reading the evidence, I do have to ask, is the victim supportive or not supportive or not in contact with the DA's office regarding the proposed plea?
Not in contact with the office, Your Honor. But initially, she was very supportive of the prosecution and moving forward.
She was.
Yes.
All right, thank you. All right, the court, having reviewed the evidence, finds that there is enough evidence to substantiate the guilt of the defendant. Court will follow the plea agreement recommendation from the DA's office, considering that the victim is supportive or was supportive of the plea. Court hereby convicts James Earl Burleson II of aggravated assault causes serious bodily injury. Court assesses his punishment at 8 years confinement. Texas Department of Criminal Justice court suspends the sentence today and places the defendant on 6 years community supervision. Court assesses a $2,000 fine and orders him to enroll and complete the batterers intervention program as a condition of community supervision. Further, the court assessed costs of $290 and reimbursement fees of $35. Mr. Burleson, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted. After that, probation officers. All right, that does complete the court's morning docket. Court will stand in recess until 1:30 for the afternoon. Where's the recess?